Welcome to the Explainer. As attorneys who are in DC Superior Court handling protection order cases day in and day out, we get asked one question all the time. How exactly does location tracking technology intersect with civil protection orders? So today, we're unpacking the practical realities of this as of 2026. Whether you're seeking a protection order or maybe facing allegations that could restrict your movements, understanding how this system actually works is absolutely crucial. We're going to look at this through a totally practical, objective lens, looking at exactly what the court can do, how the tech operates, and what it really means for your legal rights. All right, let's just strip away the mystery right off the bat. It's the core question that brings pretty much everyone to this topic. When you're looking at a civil protection order proceeding, individuals on both sides of the aisle really just want to know, can the court actually monitor where someone goes 24 hours a day, 7 days a week? Well, the answer is a definitive yes. DC courts absolutely have the legal authority to order GPS monitoring. They can do this as a condition of a civil protection order or as a condition of pretrial release in certain high-risk domestic violence cases. So this isn't science fiction, right? It's a routine legal reality right here in the district. But what does that tracking actually look like in practice? That brings us to our first main area, active versus passive monitoring. Now, there is a massive, vital distinction between the two ways the court uses this tech. Both of them do involve a non-removable, waterproof ankle bracelet equipped with a GPS receiver. But how they're applied? Vastly different. With active monitoring, the system is actually programmed with specific exclusion zones. Think of a home, a workplace, or a school. If the respondent steps into that 500 to 1,000-foot zone, real-time alerts go straight to a 24-hour monitoring center, and they can dispatch law enforcement immediately. Passive monitoring, on the other hand, doesn't send those instant alerts. What it does is create a historical log of where the wearer has been. Supervision officers then review that data periodically to make sure they're complying. So you're looking at a fundamental difference between immediate police intervention and, well, after-the-fact accountability. The system also offers something called mobile exclusion zones. Now, this is an option strictly for petitioners, the folks seeking protection, and it's completely voluntary. Petitioners can opt to carry a little GPS device or even just install a smartphone app like Sentinel Advocate. What this does is create a moving 500 to 1,000-foot protective boundary that actually follows them around wherever they go, instead of just protecting a fixed address. If the monitored respondent breaches that moving perimeter, the petitioner gets a real-time advance warning right on their device. So how well does this actually work? Let's look at the effectiveness data. Let's pause and really look at this figure for a second, because it carries a ton of weight in the courtroom. According to a multi-jurisdiction study by the National Institute of Justice, fewer than 7% of GPS-monitored defendants violate their orders by entering a prohibited location. Less than 7%. That is a striking statistic. It really goes to show that when continuous objective surveillance is applied, compliance rates are exceptionally high. And the data gives us a really clear contrast, too. When you stack GPS monitoring up against traditional supervision, standard check-ins or your basic radio frequency curfew monitoring, that same National Institute of Justice data shows a 40 to 60% reduction in no-contact violations. And it's not just fewer violations. Defendants on GPS actually have lower rates of rearrest for new offenses during the monitoring period. The court sees this data, and let me tell you, it heavily informs their willingness to impose these exact conditions. Moving on to a crucial piece of the puzzle, your rights and due process. In our day-to-day practice, we see so many people who genuinely have no idea they have concrete due process rights here. These surveillance conditions aren't just slapped on in a vacuum. Under the Fourth Amendment, which protects us against unreasonable searches, the Supreme Court actually recognized in cases like United States v. Jones that prolonged GPS tracking paints a very intimate picture of a person's life. Because of that, respondents have the right to a hearing before a GPS monitor is even imposed. You can present evidence, you can argue against the condition, you have the right to challenge or modify the order later on. You absolutely have the right to legal counsel. And on a purely practical level, you have the right to ask the court for modifications to accommodate your job, especially since these devices require hours of charging every single day. And speaking of practicalities, we've got to talk about the cost. GPS monitoring usually runs somewhere between $5 and $15 a day. Over the course of a month, that can hit up to $450. If a judge orders monitoring for, say, 6 months or a year, you're looking at a pretty substantial financial burden. But here's the thing a lot of people miss. You aren't forced into an impossible financial trap. If you physically cannot afford these daily fees, you have the right to request a fee waiver or a reduction from the court. DC courts can actually adjust these monitoring fees based on a demonstrated financial hardship, which ensures that compliance doesn't force you into financial ruin. We also need to be crystal clear about privacy. Here is exactly who gets to see this highly sensitive 24/7 location data. Pretrial or probation officers look at it to monitor compliance. The D.C. Superior Court reviews it during hearings. The Metropolitan Police Department uses it to respond to zone violations. Prosecutors can use it as highly effective time-stamped evidence in court. And, of course, your defense attorney has access to it to help prepare your case. It is a wide net of access. And honestly, that's exactly why that initial hearing to oppose or limit the monitoring is so critical. Next, let's talk about the practical limits and realities of all this. As attorneys, we can't over-dramatize the technology, and we definitely shouldn't give anyone a false sense of security. GPS devices do fail. Batteries die if the wearer doesn't charge them daily. Here in DC, we've got what we call urban canyons, those really dense areas with tall buildings plus underground parking garages, where satellite signals can degrade or just completely drop out. You also get false positive alerts, which can unfortunately lead to the wrongful arrest of a completely compliant defendant or cause real alert fatigue for victims. And look, even when an alert is 100% accurate, there is still a gap in dispatch response time. The device gives an alert. It doesn't physically act as a force field. These are just honest, practical things that both parties have to plan for. But please, do not mistake those technical limitations for legal loopholes. Following legislation signed back in 2017, D.C. closed a major gap in its laws. If a respondent intentionally removes, disables, or tampers with their GPS device, or honestly, even if they just fail to charge it, that is a completely separate criminal offense under D.C. Code. It can carry up to 180 days in jail, and that's entirely separate from whether or not the underlying protection order was actually violated.
Finally, let's discuss the role of legal counsel.
I want to highlight this quote directly from our source material because it hits the nail on the head. GPS monitoring is absolutely not a simple yes or no checklist in court. The evidentiary burden, the privacy implications, those severe penalties for violations, they all require really precise legal maneuvering. Whether you're a petitioner trying to prove that a dangerous pattern requires GPS protection, or you're a respondent arguing that less restrictive options would satisfy the court without violating your Fourth Amendment rights, these conditions really can only be effectively managed, challenged, or modified if you have experienced DC legal counsel in your corner. Which leaves us with one final thought to wrap up this explainer. The technology itself is just a tool, right? It blindly tracks location data. But that data itself doesn't protect your constitutional rights, and it doesn't automatically guarantee your safety in a courtroom. Only a focused legal strategy can do that. So if you ever find yourself navigating the complexities of the DC Superior Court, you have to ask yourself, the hardware might track the coordinates, but who is actually guiding your legal strategy? Thanks for joining us for this explainer, and keep learning.